Oh, I just realized I was thinking Judge Zayas was the presiding judge, but I think now that we're in a new year that I am the judge presiding this morning. I am very sorry about that. The first case on our docket this morning is State of Ohio versus Dominique Brantley. Counsel, are you ready to proceed?
Yes, good morning, Your Honor. Krista Gieske for defendant appellant Dominique Brantley, ready to proceed.
And Mr. Worsham, are you ready to proceed?
Yes, Your Honor. Philip Worsham representing the city of Cincinnati.
All right.
We are ready to proceed.
Ms. Gieske, you have 15 minutes. Would you like to reserve any of that 15 minutes?
Yes, 3 minutes, please.
All right. Whenever you're ready, you may begin.
Okay, thank you. May it please the court, Mr. Worsham. So as you know, Mr. Brantley was convicted of obstructing official business. And to paraphrase the statute, it provides that no person who is not privileged to do so may prevent, obstruct, or delay a public official in the performance of their duties. So today we challenge 3 elements of the statute and maintain that the record does not contain sufficient credible evidence to support those elements. So the first element that we contest is the Actus Reyes. The record does not support that Mr. Brantley acted to hamper or impede the officers in their official duties. So what the question is here is coming down off the sidewalk, and really it's a 2-part inquiry because you have the officers arresting the individual they saw on the street, Mr. Miller, I think that was the first part of the interaction. And then the second part was when they started going into Mr. Brantley's car. So the first question is coming down off the sidewalk at the behest of his friend enough to constitute an Actus Reyes for obstructing. And, you know, the officer Condon, I think it was, even testified that after he told Mr. Brantley to stay back while he was arresting Mr. Miller, Mr. Brantley complied. So there was really no obstruction there at that point. He was told to back up, he did. They arrested Mr. Miller, and then they moved on. When they went to look in Mr. Brantley's Mercedes, he then stepped back off the sidewalk and said, you know, that's my car. And that's really where I guess the focus is going to be for this court is when he then persisted to try to protect his car, was that enough to constitute obstructing? If I could direct this court back to its decision in State versus Payne in 2005, you know, the court said, quote, not every act that can conceivably be said to hinder the police rises to the level of criminal conduct. And also in Payne, quoting another First District case, Slayton, the court said that police are expected to tolerate a certain level of uncooperativeness, that it needs to be judged along a continuum. So
for clarity, is your position that there was no hindrance, or is your position that the hindrance wasn't sufficient to arise to an obstructing official business?
It's really a 2-part argument in the alternative. So the first argument is that there was not an Actus Reus sufficient to constitute any hindrance, that element wasn't met at all. And then if this court disagrees, we would say that any hindrance was de minimis and should be expected in the heightened standard that police are held to. It wasn't that big of the police officer was just clearly frustrated when you watch the body worn camera. He got mad, he reacted quickly, and this all happened pretty fast. That is our first argument, the Actus Reus. If you find the Actus Reus was met, Your Honors, we still argue that the mens rea was not met. And that is purpose. So Mr. Brantley had to have a purpose to actually obstruct.
So let me just go back to the Actus Reus real quick,
Sure.
all right?
Sure.
What do we do with the testimony that that Mr. Brantley's stepping off the sidewalk multiple times delayed the officer's ability to secure the vehicle?
That's where the court could go ahead and rule that the Actus Reus element was met. Then we would go to the privilege argument, which is actually legally cancels out the Actus Reus or cancels out liability for it, and is also a separate element of the offense that the state must meet. And we would say that he was with privilege. And truthfully, I can skip ahead to privilege because that really is, I think, the crux of this case. You know, privilege is an immunity license. It's a very broad definition when you look at 290101A12. It even says, or a status growing out of necessity. So I think it's kind of indisputable that you have a privilege by virtue of having a privacy interest in your car. The Fourth Amendment interest is a strong one. While a car is not quite as strong as a house, it is just a notch under. So the question is, do we want the police to be able to go into any car it feels like? And the answer, of course, is no. Mr. Brantley was privileged to safeguard his car. That was clearly his actual purpose.
So what I'm hearing you, and let's say that we did agree with you that Mr. Brantley was privileged to protect his vehicle, then I think the natural next question is whether the officers had privilege to secure the vehicle, and what effect does that have?
I wouldn't word it that they had a privilege to secure the vehicle, because that's it's not the same as his privilege in the statute, but regardless, the privilege is to safeguard someone's privacy interest, right? That includes not even opening the door. Two-part answer is, one, they could say, okay, it's your car, shut it off, or I'm going to. Didn't even give him that option. Step two, they could have ticketed him for that. It's a running car, unoccupied, throw a ticket on the windshield. Or if they are truly concerned about the high crime area, which we hear, and I know that Judge Bach in, I can't recall if it was a concurrence or a dissent, but I know that you separately argued in one of the opinions that we can't keep elevating this high crime area to excuse everything by police. To the trial judge's credit, they did say that the rights are the same no matter how poor you are or where you live. So the police could have gone and secured a warrant then, if they do want to go ahead and get in that car. You can't just open a door. What if there was something that they believe gave them probable cause to go further, just sitting on the seat? The whole purpose is you don't get into that car, period, unless you have cause. And they didn't have cause. At the most, they had a ticket, and they didn't want to do that. So they should have he was privileged, again, to safeguard that car. At most, they just said, okay, you need to get in there and drive it and move it or shut it off. And that's where the interaction should have ended. And in fact, if he hadn't asserted his privacy interest, that would have been a consent, an exception to the warrant requirement, a consent search. So he had to, Mr. Brantley had to assert his rights, and he did, and he was within his rights to do so. I think the last thing I'll briefly go over is just the mens rea element, since we have time.
Counselor, can I ask a quick question?
Sure.
Do the officers need a warrant to simply turn off the car? I know what you're saying is they would need a warrant, but wouldn't that be to search the car? In this case, if they were just turning off the car for safety purposes, would they need a warrant for that?
I would say you need a warrant to get in the car when the owner is right there. And these are very fact-intensive inquiries, of course. If no one was standing there at all and a car is just running, I would say, okay, if no one's owning up to that car, the police can go in and shut it off. But if the owner's right there, let's take it to the easier example of a house. Just because the officers want to go in someone's house to supposedly secure it, are they allowed? No. You need a warrant.
Looking at the facts in this case, as I understood them, when the officers asked with regard to the ownership of the vehicle, Mr. Brantley did not initially take ownership of the vehicle. I believe that he responded like it's none of your business.
He did, and there was a precise, I took detailed notes on the body-worn camera interaction, and there was exactly a 4-second elapsement between him saying none of your business, and then they're like, all right, we're going to look into that car, and then he said, it's mine. It was 4 seconds. So that's not very long, and shouldn't really affect the analysis, I don't think.
So I think that leads then to the question is, under those circumstances, was that enough for there to be a clear understanding as to who the owner of the vehicle was?
I think so. And if there wasn't, the officer admitted they never even tried to look up, even after Mr. Miller was secured in the back of the cruiser, they didn't even try to go and look up the license plate. They just went into the car.
So is it your position that they had a duty to then look up the license plate before they would have entered the vehicle to secure the vehicle by removing the keys?
No, it's my position that they had a duty to say, okay, this is your card, turn it off or move it. They can't just go into it. The alternative would be, yes, then to go and do further investigation to see whose car it is once the arrest was over, which was over pretty quick. If the car is still sitting there, the problem would have resolved itself. If it was his car, he can get in it and move it. If it wasn't, they can sit there and look it up because it's not moving if it's not his. If there are no further questions, I think I'll reserve the remainder of my time for rebuttal.
All right, then you will have 5 minutes left.
Okay, thank you.
Mr. Worsham?
Yes, Your Honor. May it please the court and opposing counsel. This court should affirm the trial court's decision because Brantley's conviction for obstruction of official business was supported by sufficient evidence and was not against the manifest weight of the evidence or otherwise contrary to law. And this is because in reviewing whether conviction is supported by sufficient evidence, a court should determine whether after reviewing the probative evidence and inferences reasonably drawn therefrom the most favorable to the prosecution, any rational trier of fact could have found all their essential elements beyond a reasonable doubt. And then in deciding whether conviction is against the manifest weight of the evidence, an appellate court determines whether the state has appropriately carried its burden of persuasion. A reviewing court must consider the entire record, weigh the evidence and all reasonable inferences, and consider the credibility of the witnesses and determine whether the trier of fact clearly lost its way and created such a miscarriage of justice that the conviction must be reversed. Under the obstruction of official business statute, Ohio Revised Code 2921.31, excuse me, it states no person without the privilege to do so and with purpose to prevent, obstruct, or delay the performance by a public official of any authorized act within the public official's official capacity shall do any act that hampers or impedes a public official in the performance of the public official's lawful duties. And then law enforcement officers are public officials under Ohio Revised Codes 2921.01 Section A. And then also under 2921. Yes.
Which facts would you say go towards impeding the officer's official duties in this case?
I would say the facts that go to impeding the officer's official duties. The first would be when Officer Condon is trying to arrest, I believe it's Mr. Miller at the time, who had open warrants. As he was trying to arrest him, I believe he said, everyone's, stay back, arresting prisoner. And that's when Mr. Brantley comes up and reaches for the belt, which interferes with Officer Condon and trying to secure Mr. Miller. Officer Condon eventually testifies that he wasn't able to do a more thorough search due to having to divert his attention because Mr. Brantley came up and interfered with him while he was trying to place Mr. Miller under arrest.
Mr. Worsham, just one point of clarification on that. Actually, 2 points. Before Mr. Brantley reached for the keys, did you say that the officers told everybody to stay back? Was that on the video?
I believe that was on the video, Your Honor, from when I reviewed. I believe they're telling, people to stay back at the time. And then Mr. Brantley then does approach, tries to reach for the belt, and then he tells them to stay back again after that.
Okay. All right. Continue on with Judge Zayas's question then, please.
And then also during that interaction, I would say the other factor that would go to impeding the investigation is when they're trying to, the officers also had a duty to, investigate the unoccupied running vehicle. And as they're, my understanding from the transcript, when they're trying to at least turn the vehicle off, that's where Mr. Brantley approaches again. And I believe during that interaction, he was told to, or Officer Condon told him to step back. before.
Attorney Worsham, as you already know, one of the arguments is with regard to privilege. And the argument is that Mr. Brantley had privilege to protect his vehicle. You just talked with regard to the duty of the officer to securing. So what is your position as to what effect does that duty have on Mr. Brantley's privilege towards his vehicle?
Yes, I'm sorry, could you repeat the question one more time?
You just talked about the officer's duty to secure the vehicle because it was a running vehicle. And I believe you talked specifically to removing the keys from the vehicle.
That is correct.
Okay, so what effect, if anything, does that duty have on Mr. Brantley's privilege to protect his vehicle?
With regards to Mr. Brantley's privilege to his vehicle, I would argue that he doesn't have the privilege to interfere with the officer's arrest or investigation. I know initially during the video, at the believe the Second Mark Council reference where he eventually admits to ownership of the vehicle. At first he said it's none of your business, and then I believe he might have stated it's my car, or are you talking about the car across the street? And then Officer Condon, I believe when I rewatched it, asked him again, are you the owner of this Mercedes? And Mercedes was the unoccupied running vehicle at the time. And when I rewatched it, he didn't state again that it was his vehicle. And then I don't believe he takes, at least clear ownership again until, as the officer's attempting to, turn the vehicle off, then he comes up and says, oh, it's, my vehicle, or, he says, don't touch that, that's my vehicle. I believe at that time, and even the court on page 85 of the transcript, stated that at that time, they don't believe the officers knew right away who owned the vehicle. They were just trying to secure the vehicle, turn it off, and they had already told Mr. Brantley to stay on the sidewalk beforehand a couple of times, and Mr. Brantley came back to, approach the vehicles as they were trying to, turn the vehicle off. So, the officer has a duty to make sure there's no unoccupied running vehicles. The officer just trying to, officer testified he was just trying to, secure the vehicle, figure out who owned the vehicle. And, Mr. Brantley was interfering with that. Mr. Brantley, I believe at that point, does not have the privilege to interfere with the arrest with Mr. Miller earlier, or with interfering their investigation of who owned, or, who was the owner of the vehicle, because they were just trying to secure, the area. And they had already told him, step back. And during that time, I don't believe Mr. Brantley, until they tried to, get in the car and turn the vehicle off, had asserted that that was his vehicle.
The officer's duty to determine who owned the vehicle, what is your position as to whether there was sufficient facts so that that had already been met, that the officer knew who the owner of the vehicle was?
I believe the officer had, testified that, Mr. Brantley's actions, hampered his ability to find out right away who owned the vehicle. The officer, stated that, Mr. Brantley constantly coming up, he wasn't able to look. The video is a very, quick video. Everything kind of happened pretty quickly. He wasn't able to fully, and the officer kind of testified, he wasn't able to fully, determine who was the owner of the vehicle. He wasn't able to fully do a thorough search of Mr. Miller when he was trying to arrest him, and Brantley tried to reach for him. He wasn't able to do things fully because Mr. Brantley's actions hamper him for doing things fully at that point of time.
Well, ultimately, the trial court's conviction, wasn't it based solely on the hampering, the securing of the vehicle?
I believe the trial court's decision, when it wasn't only solely on the vehicle portion, I believe the trial court also would have came to the conclusion that his actions interfering while he was trying to arrest Mr. Miller was also went to the impeding of the investigation. You know, Mr. Brantley may have a privilege for his car, but he doesn't have the privilege to interfere with an arrest or with the investigation, and with specifically with back to the arrest portion. You know, Mr. Brantley clearly sees that he has Mr. Miller in handcuffs. He's trying to, secure and search him, and he still goes up and reaches towards the belt area. And at that time, Officer Condon doesn't, know what Mr. Brantley's, intentions are, and that kind of diverts his attention from doing a more thorough search of Mr. Brantley. So I believe the trial court's decision was kind of the total, the totality of the circumstances, all of Mr. Brantley's conduct. The trial court came to the conclusion that all of his conduct was, impeded the officer's official duty. And and then with regards, back to the argument, the affirmative act that we would argue is the affirmative act Mr. Brantley had at first was interfering, with the arrest. Officer Condon is trying to arrest Mr. Miller. Mr. Brantley comes up, reaches for the belt area. He got so close that Officer Condon had to push him back. He pushed him back, and he wasn't able to do a more thorough search. He had to hurry up his arrest to do that. And then the other, affirmative act, we would argue is that when he, as Officer Condon is trying to turn the vehicle off, that's when Mr. Brantley comes back up, kind of impedes their investigation of the vehicle at that point in time. So we believe there's at least an affirmative act. And then with regards to the privilege, the state would argue that Mr. Brantley, he may have a privilege for his car, but he doesn't have a privilege to impede an investigation or interfere with the officer while he's trying to make an arrest. And, if the court, we would argue the court finds that he did have the privilege, then, law enforcement officers, they wouldn't be able to arrest people on open warrants without interference.
So under what circumstances would privilege apply then? Because based on what you just said, it almost sounds like that part of the statute doesn't really mean anything.
I believe in this case, as far as the privilege element, Mr. Brantley's, whether he had privilege to his car or not, it doesn't give him the right to, interfere with an arrest. And then when they told him to set back multiple times, I know there's the, with regards to the ownership of the vehicle, at first he says none of your business. And then when the officer, and, he kind of, asserts that, well, it is his vehicle. But then when officer kind of asks him again, are you the owner of this Mercedes? When I rewatched the video, I didn't hear him say it was my vehicle. And then he doesn't say anything again with regards to the vehicle till later on. And then even in the transcript, we eventually find out that Mr. Brantley doesn't even own the vehicle. He was just using on that day. I would say with regards to the privilege element, privilege doesn't give someone the right to interfere with arrest or impede an investigation. He was not acting.
Mr. Worsham, you have about 1 minute left.
Okay. And then just to briefly to conclude, Brantley did not act with privilege when he was impeding the investigation of the officers. The police had the right to make sure the vehicle was no longer running since the vehicle was parked illegally and it was running. And then because Brantley must prove that he was privileged in obstructing the officers when they were arresting a person on an open warrant, In investigating legally parked cars, the totality of the circumstances clearly establishes that Brantley was not exercising privilege when he hampered the officers while they were performing their duties. And based on that fact, we believe the court should affirm the trial court's decision.
Thank you. Ms. Gieske, I think I told you 4 minutes. I think you actually have 5 minutes left. So whenever you're ready.
Good, thank you. There's quite a bit that I would like to clarify. The point at which Mr. Brantley says on the camera that it is his car is at the 58-second mark. If you want to go back and look at that, which was 4 seconds after he said none of your business. The fact that it's a loaner car, A, that didn't come out till sentencing hearing and mitigation, so that's not appropriate evidence to consider in the merits of the case. And B, the Fourth Amendment still applies to a rental car. I've had that in my cases before. The law applies. You still have an ownership interest in a loaner car or a rental car. The state, when they argue that he wasn't privileged to obstruct the investigation, this is what is known as a strawman argument. So it's a logical fallacy that you set up to say it's easy to knock down that distorted argument. That's not what we're saying, that he has a right or privilege to break the law. This is how privilege works. It removes liability because you have the right to act. So let's take a very easy example, a driver's license. That's in the definition of a privilege, a license. You have a license to drive a car. You have a right to drive that car. If you drive unlicensed, you are breaking the law, and that is a citable offense. So he had a privilege to approach and safeguard his Fourth Amendment interest, and that does take it out of legal liability. That is what the whole way privilege works. The state does not correctly summarize the trial court's decision. The trial court said that when he went to grab the keys, and for one, I believe the officer didn't say stay back until after the first time Mr. Brantley stepped off. I apologize, I would have to rewatch the video again, but according to my notes, they went up to effectuate the arrest. Then he approached to get the keys from Rico, Mr. Miller, and then they said, step back. I believe that was time one. Officer Condon admitted, once you said stay away while we're doing this arrest, did Mr. Brantley stay away? He did. So I don't think that part, and then when the trial court rendered its decision, it said that when Mr. Brantley went to grab the keys, that shifted things. It didn't say that was the obstruction. So I do think this entire case hinges upon the interaction with the Mercedes. To Judge Zayas's question, did the duty to investigate obliterate the privilege? Did the duty to investigate a running car? We would argue, no, it didn't obviate his privilege. The privilege doesn't go away just because a car is sitting and running. Again, that is a citable offense. It's a misdemeanor offense. It is an impeding traffic.
My question was what effect it has.
Okay, and we would say that is to Judge Bach's question, that is how the privilege operates. So they might have a duty to investigate, but if that duty is, if their ability to investigate is cut off by the exertion of someone's privilege, they can't go any further. Again, that is how the legal concept of privilege operates. And my last question would be, to the officer is, where is the exigency? The traffic code is to maintain safety and to not impede the flow of traffic. So, if there's a car running, the car was in park, again, he could have gotten in his cruiser and then sat and watched what happened to that car. Mr. Brantley's either going to get in it and drive away or he's not. What's the exigency? He tried to say, but there could have been a gun in that car. Well, you can't use that to justify everything everywhere, especially these days. You can't get into someone's car just because you think it's a high crime area. There might be a gun. He's a young Black man. He gave me lip at first. Who cares? You're a police officer. You need to handle some amount of resistance. He wasn't being belligerent. He wasn't being nasty. He was just asserting his rights. So it is our position that the elements are not met, but at most the court, we implore the court to recognize the operation of privilege under these circumstances. If there are no further questions, we would ask that the court reverse and discharge Mr. Brantley from further prosecution or remand for a new trial.
Thank you. Does the panel have any further questions of Ms. Gieske? All right, thank you very much. That will conclude the arguments in our first case today. We will take the case under submission and give you a timely written opinion. Thank you both very much. And if you will bring the next group into the courtroom, please. All right, Mr. Kathy, I don't know if you're intending to turn on your video. And I assume there. All right, there you are. Mr. Galasso is here. Our next case is 255 Fifth Street Holdings versus 255 Fifth Street Limited Partnership. Mr. Galasso is here on behalf of appellants. Mr. Kathy is here on behalf of appellees. Mr. Galasso, you have 15 minutes to argue this morning. Would you like to reserve any time?
Yes, Your Honor, I would reserve 10 minutes for rebuttal.
All right, that will give you 5 minutes to start, so whenever you're ready.
Thank you, Your Honor. May it please the court. This appeal arises from a commercial mortgage foreclosure in Cincinnati. The facts of the case aren't really at issue, and they've been briefed, so I won't go into those in oral argument. Our firm represents the borrowers who are the owners of the property, who borrowed money under a non-recourse loan prior to foreclosure. The lender is an investor who acquired the loan after it went into default. And unlike the borrowers, the current lender was not a party to the negotiation or execution of the original loan documents and does not have any knowledge of the intent of the original parties to those documents. The lender that's here today is not really a lender. It's a hedge fund that's not in the business of making commercial loans.
Well, is it your position that we even get to intent? Is your position that the contract is ambiguous?
Your Honor, I don't think it's ambiguous, but I think the intent of the parties is expressed in the express language of the contract. And I think that's how both of the federal cases that we cited were decided. So the issue presented on this appeal is very simple and very focused. The issue is whether the lender had a security interest in cash in deposit accounts that was deposited into those accounts prior to default. And the clear, unequivocal answer to that question is no, for 3 primary reasons. And the first reason is that under Ohio law, as with other states, a non-recourse loan only subjects the collateral to the lender's claims. And the collateral is what was pledged through the mortgage and assignment of rents, and the borrowers don't have any personal liability. Secondly, the loan documents provide a specific process for the lender to obtain a security interest in cash and deposit accounts. And that specific process in the loan documents requires that the account either be 1, held, or 2, created by the lender or the loan documents. And that unequivocally did not happen here. And because the lender recognizes that it hasn't satisfied the requirements to take control or to take these deposit accounts as collateral, it asked this court to instead consider the deposit accounts to be rents. And rents are separately defined in the loan documents as payment obligations that come from the tenants as a result of their leasehold at the property. It is not the same thing as cash in a deposit account. So the lender's argument that rent is rent forever has no support in the loan documents or Ohio law. And if that position were true, there'd be no reason to have the provisions in the documents relating to the deposit accounts.
I assume you would focus our attention on section 2.7. And Mr. Kathy, when we get to you, I'm going to sort of ask you the same question. But if I understand your argument, Mr. Galasso, your argument is 2.7 defines what's to be done with rent, what is rent, when the lender can take and collect rent. And is that what you're focusing
Yes,
us
Judge
in on?
Myers. So the
All
loan documents here use language such as until an event of default and thereafter, and use this prospective language. That is the same language that was used in the loan documents in the 2 federal cases on which we rely. So basically what we're saying is that the cash at issue in this is not rents, it's cash in a deposit accounts, and it's not part of the lender's collateral, only those rents that were generated after default. So the third reason—
That's because they didn't— Go ahead, Judge Box.
Thank you, Judge Myers. Was this money rents before it was transferred into the other account the day before the default?
No, Your Honor. So rents is a prospective item. It's a real estate item. It's not a UCC item. And what happens is rent is something that's paid by a tenant. Once the rent is received by the borrower/owner, it becomes cash, and the cash goes into a deposit account. And if the lender wants to take a lien on that cash, then it would follow the process that's in the loan documents. And finally, the third point that I wanted to make in my case is that the lender in this case is attempting to distinguish our federal cases by saying that the assignment of rents in this case is absolute and that the assignment in the two federal cases is not. And that's really a red herring. Our case does not involve an absolute assignment of rents. It's an assignment for the security of debt. And that's best evidenced by there's a seminal case out of the Sixth Circuit from 2010 called Buttermilk Town Center. And it has the three factors for what's an absolute versus a conditional assignment. And when you apply those three factors, our assignment of rents is not absolute. So that's also not a relevant argument for the court to not follow our precedent. So through this appeal,
you are at your time. You are at your time if you'd like to reserve 10.
Yeah, I'd like to reserve 10, Your Honor.
All right. Mr. Kathy, you'll have 15 minutes, but if you'll indulge me, if I can ask you a question right off the bat, because this has been on my mind. Take a look. Do you have section 2.7 in front of you?
I do. Can you hear me okay, Connor?
Pardon me?
Can you hear me okay?
Yes.
Okay, good. Okay, thank you.
All right. Tell me where I'm going wrong in reading this. The beginning of 2.7 provides that all existing and future rents, a defined term, it gives the borrower is assigning to the lender all existing and future rents. In other words, rents that are currently owed but not collected in any future rents. And then lender is given the right to collect that rent, but unless an event of a default occurs, the borrower is given a license to collect that rent. In other words, at that point in time, the lender is giving up its right to collect it, and it's allowing the borrower to collect the rent. And it's only when an event of default occurs that the license terminates and the right to collect the rent automatically reverts back to the lender. And at that point in time, the lender is allowed to collect it and keep it to satisfy the debt. Would you agree so far with that?
Somewhat.
Where do you disagree? That's what I
would, yeah, Your Honor. So the provisions in play here in these loan documents are obviously section 2.7, which we spent a lot of time on in the briefing and in the lower court and so forth. But there's also the leasehold assignment of rents that has, and that's Exhibit C to the complaint docket number 2. And that has on page 2, paragraph 2, has similar language as in 2.7. So I want to, they basically mirror each other, but there's a couple of slight differences in the language. So the way this was set up.
But your client doesn't have the right to collect the rents unless an event of default occurs. What you're arguing is existing collected rent retains its character as rent, and your client has a security interest in that, what I'll call a cash account, you might call a rent account. That's your argument.
I don't know. I don't think that's not exactly what we're arguing. So let me, if you can just let me explain a little bit, then we can kind of delve back into your questions. Number one, if you look at how these documents are structured, there's a granting clause in the mortgage. And in that granting clause, it says borrower, opposing counsel's client, does hereby irrevocably, absolutely, and unconditionally transfer, sell, assign, pledge, convey to lender, its successors, and assigns all of the right, title, and interest of borrower in, and then it goes through a number of things. All deposits, rents, issues, profits, royalties, accounts, rights, benefits, essentially any and all proceeds, monies, leases, what have you, generated from this property. And then the provisions at issue here, that license goes from my client to the borrower, okay? Then if there is an advantage, I can't hear you, Judge.
I'm sorry, I agree
That's
with,
okay.
I think that's, I agree with that.
Okay, all right. And that's the distinguishing feature here. There was upon execution of these loan documents in April of 2006, there was an immediate conveyance by the borrower to the lender. And if there is an event of default, that license that my client then grants back to the borrower terminates, evaporates. And those rents then become, or actually the borrowers then become the agent and must immediately turn over those rents to the landlord. These two provisions themselves do not delineate between rents collected before and rents collected after.
Except that last phrase of 2.7 says, from and after the termination of the license, borrower shall be the agent of lender in collection of the rents, and all the rents and profits so collected by borrower shall be held in trust by the borrower, et cetera, et cetera. Doesn't that refer solely to rents to be collected, not past rents already collected? Because
No.
it says to be collected.
No, Your Honor.
How does that go back in time to a cash account of rents?
The rents themselves were collected, okay? But they weren't used, enjoyed, what have you. There was a pool of money. And in contrary, there's a lot of things that Mr. Galasso said that I would just tell the panel that aren't supported by any evidence in the record. But regardless, the rents themselves don't lose their character as rents simply because somebody makes a payment, either via wire into an operating account, writes a check, or what have you. They're still rents. And my client's security interest.
Well, let me push you on that
rents.
a little bit. Let me push you on that a little bit. Is that really true? Let's say I'm a landlord, I own property, I collect rent. Once I collect the rent and I put it on my checking account, it's not rent, it's cash. I mean, the source of the cash was rent. Just like if I receive money from interest on a savings account, that's the source of it. What's your position? Why does it maintain its character as rent in perpetuity?
Well, to follow your logic there, if they no longer become rents once they hit an operating account, or the day before the loan goes into default, they move it into another account, then any post-default rents that hit an account, my client would then have to go and take a bunch of steps to control, and they would lose their character as rents.
No, because the documents themselves say once that event of default occurs, either your client can collect it itself or the borrower is obligated to put it into a trust account.
Well, provided certain
The
steps.
difference.
Okay,
Yeah.
well, they don't lose their characters, right? And if you look at sorry, do you want to say something?
I didn't mean to get into all of the murkiness of the words, but I think they're important. So thank you for indulging me with all of those questions.
Sure, Your Honor.
Well,
Sorry to
Attorney
interrupt.
Kathy.
Yes, Your Honor.
Am I pronouncing your name correctly?
Kathy, that's correct. Yes.
Okay, Attorney Kathy, indulge me on this, okay?
Sure.
So I know it's going to be hard, but let's work on the assumption that the definition of rents is not what your position is. that once it's collected, it becomes cash. Okay? So that's the basis of my question, and this is what my question is. I noticed that your client also had as collateral profits. So what effect does that term then have with regard to the outcome of this case?
Well, the pledge of security in basically any cash that's generated from the property is expansive. And the idea is that once that license expires, any money that's remaining in the property belongs to my client. So it really doesn't matter whether it's profits, rents, because the loan documents, they contracted a certain way. And the loan documents say that my client has an interest in all of these things. And the money was never sent to the borrowers at all. The money was sitting there.
I think under the definition, under the alternate definition of rents, once it's collected, it's no longer rents. So when it's sitting in an account, it might be profits, it might be operating expenses, but it's no longer rents. And I'm not talking about your definition of rents, okay? So that's why I'm asking the question, not based on your definition of rents, but if rents are no longer rents once they're collected, then because they've been collected, then they're no longer, there's no right to them as collateral because they've been collected. But I noticed that your client had as collateral profits.
Right, and I guess, Your Honor, I'm not following
It just seems
your
to
question.
me that if a rent is collected and it's no longer rent, then that's no longer collateral. If it hasn't been collected, then, you know, I'm under the alternate definition, okay? But profits is something that profits are profits, right? And so if it's sitting in an account and it's a profit and that's collateral, then what the default and anything doesn't change the nature of that being profit.
Okay, but
In other words,
when is a rent? I guess the question is, when is a rent a rent? Because if I'm a tenant and I'm holding rent money, and then you hand it over to the landlord, which would be the borrower in this case, they all of a sudden lose their status as rents because they went from borrower, not paid, unpaid, to a landlord. I mean, that doesn't make any sense from a legal standpoint. And I think, you know, this is not it seems easy, right? It seems, you know, the parties agree that the court's got to look at the four corners of the contract. We're not disagreeing about what words are on the piece of paper, essentially. And we're not disagreeing that this is really a case of first impression in Ohio. Where we disagree is obviously what the terms mean and how they're applied. But if you look at these other cases around the country, how do you make sense of them? How do you make sense of a North Carolina federal bankruptcy case, okay, from 1997, the Grandfather Mountain case? How do you make sense of the 3 Flint Hill case? How do you make sense?
If I'm understanding your definition of rents, then that means that all rents ever collected are collateral and that your client would have rights to them upon default. So looking from the moment of defaults backwards, under your definition of rents, everything was rent.
If the rent monies were spent, they no longer exist, but they're remaining in the property. They're subject to my client's security interest.
I think that goes to my point, because I'm looking at like 2.7, and it says all existing future rents and all existing and future rents and profits.
Right.
I mean, this is clearly a case where what these words are intended to mean or actually mean is what's at odds.
Agreed, but if you start looking and you analyze how these courts came up with the decisions they came up with, if you look at 3 Flint Hill, again, that was a conditional assignment. And the court actually looking at a prior case from that jurisdiction, the AAI Carmel case, found that their conclusion would have been different, or may have been different if it involved an absolute assignment of rents. If you look at the 3 Flint Hill case, if you look at the language of that document, the assignment in that case became operative upon the occurrence of an event of default, and to remain in full force and effect so long as an event of default continues to exist. I mean, there's the language of those documents is very, very different. And this court has previously recognized absolute assignments of rent with language nearly identical. And that's the U.S. Bank trustee versus the P.E. Alms case I handled until I left my prior firm. And in that case, it was involving a present immediate conveyance of all rents, profits, what have you, okay, with a license.
Let me interrupt you for just 1 second, please. Going off what Judge Zayas was asking, how do you define what is a profit? As in relation to rents, exactly what is a profit in paragraph 2.27? 2.7, I'm sorry.
2.7 doesn't define what a profit is. I mean, there's an expansive definition of it, but parsing every little word in this provision is, I don't know that it really makes a difference, because my client has a security interest in all of these things. There's a number of things that constitute rents and profits under this leasehold mortgage. And they're all provided, they were all immediately conveyed to my client at the inception of the loan, and then licensed back. So whether it's a rent, it's a profit, is really not, in my opinion, respectfully, not germane to the issue. I think the issue really comes down to looking at all this. What's the type of instrument that we're dealing with here? Okay, and that's really the distinguishing feature.
Mr. Cathy, you are at your time, but I'm going to allow the panel to ask any follow-up questions, because we monopolized a lot of your time with our questions. We may still have some more left. Are there any other questions from Mr. Cathy? I guess I have one final question, Mr. Cathy, and that is, if there were delinquent rents, let's say these rents that we're talking about that were paid right immediately prior to default, if the tenant had not paid those rents and they were due and owing, I assume your argument would be that those are, even under some of the hypotheticals we've thrown at you, that would fall under 2.7 and would immediately, once the license was canceled, your client would have the right to collect those unpaid rents.
Absolutely.
So the difference is timing, and part of your argument is that shouldn't make any difference because we've got a blanket security interest, whether the rents were paid on time or weren't paid on time. My client has an interest in those funds.
Correct. The funds themselves are identifiable. About monies that were paid 10 years ago to a plumber was received as rents and paid out to pay bills. That's a much different situation. That money's gone. We're talking here where we don't disagree as to what the money is, what's sitting in the trust account, essentially waiting determination by the court.
All right, thank you. Any other follow-up questions from the panel? All right, thank you, Mr. Cathy. Mr. Galasso, you have 10 minutes. And would you please start with that question I just asked Mr. Cathy? Would you agree that had those rents not been collected but were delinquent, still owing at the time of default, that Mr. Cathy's client would be entitled to them?
Yes, Your Honor. It is our legal position for this case that the sole legal issue is whether the lender has the entitlement to rents that were collected, retained, used, and enjoyed prior to the event of default. If rent were payable after default, the license would have been revoked, and then the lender would be able to attach those rents.
What is your position with regard to Attorney Kathy's client's rights as to any profits at the time of the default?
So,
Pre-existing
Your Honor,
profits.
yes, Your Honor. So I think what the loan instruments do is that they broadly define any income that comes from the property as being, subject to the assignment of rents. And so they call it rents, issues, profits, revenues, royalties, rights, benefits, income. And so the term rents and profits, to me, it's all the same thing. It's just money that comes from the tenant. But the lender's position in this case,
collectively the rents and profits. So
yes,
it enumerates all these things and then refers to it as collectively the rents and profits. Obviously, all of these things enumerated, they don't all fall into being both rents and profits. Some of them fall into rents, some of them fall into profits.
And so, Your Honor, my position would be that rents and profits refers to money that comes from the property, from ownership of the property that would go to the borrower that's been pledged as security here. But it's not cash in a deposit account. That's a totally separate concept. And so it is our position.
Would you say that the term rents and the term profits are secular?
No, Your Honor, I would consider them to be almost analogous. Rents and profits are money that comes from the property. And so if you can call it a rent, you can call it profit, revenue, income, we would consider those to be analogous terms. So, Your Honor, I wanted to touch base on two main things. One is this absolute versus conditional assignment argument, okay? Because the adjective that you use is not determinative here, okay? And so the Buttermilk Crossing case puts forth three factors where the borrower retains the right to collect the rent, where the rent is pledged for security of a debt, and then the right terminates. It's not an absolute assignment where the assignment transfers. So I just want to be clear that this is not an absolute assignment of rents. And there was actually a case cited by the lender in its brief that said that, that this is an absolute assignment based on a case from this court in 2017 called P.E. Alms. But all that case did was hold that there was an assignment of rent sufficient to appoint a receiver. It had nothing to do with whether an assignment was conditional or absolute. And this is plainly absolute. Or I'm sorry, it's plainly conditional assignment. So this absolute argument.
How is rents defined in that case? Or how? Because we're at issue as to what rents mean.
So it was defined in substantially the same way, Your Honor. Basically, all of these cases involve a pledge of the rent and income and profits, and then a conditional license back to collect it and absent a default. And so it's the language can change slightly, but the structure is the same and the definitions are the same.
What I was asking is this, and maybe I didn't ask it clear enough, is, and I'm going to use Judge Meyer's term of delinquent rents. Whether rents is intended to be delinquent rents and future rents at the time of default, or whether rents is intended to be all rents that ever existed from the very beginning of the loan all the way to the time of default and beyond. Okay,
so let me answer that question in two ways, Judge. Rent that is paid after an event of default is not an issue in this case, and we don't claim that it would be. What we're claiming is rent paid prior to default. And so these cases that were decided under Virginia law and North Carolina law, yes, there is specific state law issues related to assignments of rents, but both of those cases were decided on basic contract principles where it was found to be the intent of the parties that a conditional license that you have the right to collect and retain the rent until an event of default evidences an intent that only prospectively rents that come after default would fall within that gambit. And so rent that was received prior to that time would not. Let me wrap that back up into this court's own precedent. So there's a 1932 case called Norwood Savings Bank versus Romer. It's decided 60 years prior to either of these two federal cases. The facts are a little bit different. In that case, the first mortgage holder came after the second mortgage holder and said, we want the rents that you collected. And the court framed the issue, this court framed the issue as follows. Does a pledge of rents and profits reach the rents accruing before condition broken? Just a different way of reframing the same issue that's in our case. And basically the court said, look, Ohio law provides that the owner retains the rents until he's either one, ejected from possession, or two, the right of redemption is terminated. So this assignment of rents only attaches prospectively. And I would like to read a quote from that because it dovetails right into all questions that have come from all three judges on this panel. It says, if the plaintiff's contention was correct, and that can be this analogous to the lender in our case, in all cases of real estate mortgage which pledge rents and profits, and this pledge is the usual form of such mortgages, it would require the mortgagor to impound the rents until it should be ascertained whether the conditions of the mortgage would be broken. In other words, my clients would have to retain $167 million till the end of this loan to understand whether or not there would be a default, or it would be subject to this retroactive claim as rents. And it says that, it's kind of striking that in 1932 that this court would say basically the same thing as the two federal courts' decisions. It says the contention of the plaintiff bank would lead to the situation that had the mortgagor, in our case the borrowers, use the rents for purchases from the merchant, the grocer, or the butcher. Such persons receiving the same in payment of their debts would have to give them back to the plaintiff bank. It may be stated that this would be reductio ad absurdum, but it illustrates the extent to which the proposition might lead. And so that's what we're saying in this case. There is no way to delineate between what money the lender is asking for in this case and what has been received prior to default. And so that license to retain, to collect, to use and enjoy means that they keep that money until there's an event of default. And when that happens, then rents paid after that are subject to the lender's claim, but not rent before. And it just makes no business sense for this to operate in any other way. And I'll note one more thing. It's in a footnote.
Before you move on, can I ask you just a basic question? And the reason that Mr. Cathy's client can't get those funds, those pre-default funds under your interpretation is because it's a non-recourse loan. And therefore, even though there's an assignment of rents, he can't claw back because it's a non-recourse loan.
That's correct, Judge. That's one of the reasons. But I'll note that one of the things that was said in the three Flint Hill cases that the parties disputed whether the note was non-recourse, and the court found that it didn't matter. So it doesn't matter in the sense that rents are not rents forever. And once paid, collected, retained, put in an account, whether they've been used for something or not used for something, once those rents are collected and retained, they're out of the collateral. It's been incrementally extinguished by, the ongoing obligations of the note. It is even more pronounced in this case because it's non-recourse, and now my clients are going to be held personally liable under the lender's theory of liability here. But one of the other things I wanted to point out was that in the last footnote in the Grandfather Mountain case, the court noted that he says, as lender's counsel conceded an oral argument, it would be improper for the court to fund trace the rents if they have been put to the purchase of an aircraft. The court is not inclined to alter this result simply because the debtor put the money in an account. So it doesn't matter. Mr. Cathy's argument that this money had not been directed to some specific purpose does not alter any of this analysis. Rents are not rents forever, and the collateral did not include these deposit accounts that covered this cash.
All right, thank you very much, Mr. Galasso. Any other follow-up questions from the panel? Thanks to both of you for your arguments this morning, and thanks for your willingness to indulge all of our questions. We will take the case Mr. Kathy?
You're right. I just want to, can I point out just two quick things?
Well, I'll let you point out two quick things, but Mr. Galasso is going to get equal time.
Well, okay, the first thing is, with respect to the Norwood savings case of 1932, that Mr. Galasso spent a lot of time going over.
Mr. Kathy, let me stop you there because I don't recall, was that case raised by him in his brief?
It was not in his opening brief, it was raised on reply.
Well, no, I'm not going to let you make any more points. And that's only because all of this was in the brief and we delineate the arguments for a reason.
All right,
So I assure you, we will fully study all of the legal precedent and all of the arguments made.
okay. I just make one argument by opposing counsel.
I couldn't
that butter-
understand what you just said.
Sorry, Your Honor. That buttermilk crossing case that he refers to wasn't cited in any brief at all.
Then I'll let you address that very briefly.
Again, I didn't think I was going to be blindsided by that case today, but that case was a bankruptcy case, a Sixth Circuit case, but it was a bankruptcy case, and it construed law. We're obviously dealing in Ohio law, and we're really looking at the four corners of the contract is the bottom line. But again, it was a case that was never addressed, so I don't think it's improper for him to be bringing it up during the oral argument.
All right. Thank you, Mr. Kathy. Mr. Galasso, I don't think there's anything you need to respond to. So I'll give you just 30 seconds if you feel a need to respond.
No, Your Honor, I appreciate the opportunity to do that and we'll rest our case.
All right. Again, thank you both very much for your arguments today. We will take this case under submission and give you a timely written opinion. That will conclude this morning's arguments for the First District Court of Appeal. Thanks, everybody.
All right, thank you.